You're listening to Where You Live with Gene and Tony.
Welcome back to Hour 2 of Where You Live with Gene and Tony. And today we're talking about a lot of different articles that have been coming up in the paper. We talked about HOA that was concerned about trains that were parked by their
That's right.
by their homes. We've talked about bullying, and we had an interesting comment.
Yeah, we had a caller during the last segment who did not want to go on air, but she really related, and that story about bullying really resonated for her because she has suffered bullying in her life. And she said, as a kid and even now as an elderly person in a care facility, she feels she is bullied sometimes.
Yeah.
It hits all of us at some point. If it hasn't happened to you personally, it's probably happened to someone you know and love, like a child or a spouse or a parent.
Yeah. And so we can talk again about any of these topics. You've heard our opinion, but if you want to give us a call to talk about that, we'll stop and talk about those.
651-289-4488 is the number.
Yes, but why don't we go ahead with the next topic? And this is the one that I'm really interested in. This is in Florida. Just this last July, Tony, the state legislature there passed, I want to say, probably 7 or 8 very significant laws that govern homeowner associations. Okay. And this one deals with the collection of delinquent dues,
which is a huge issue for many associations.
Oh, yeah.
During this economic crisis we're going through.
And one of the reasons why on the show we usually go through a lot of stories that come out of Florida is because I think everybody probably knows and understands. I think Florida is the state of homeowner associations.
Yeah, certainly the earliest I ever heard of homeowner associations was out of Florida, and a good percentage of their real estate is held within homeowner associations.
Yeah, so you have that. They've been HOAs longer. You have the population, which is much more than Minnesota.
Yeah.
So you're going to probably see things happen there before they migrate to other parts of the country.
Sure.
And so one of the reasons we always have our eye on places like California, Virginia, Texas, is because some of those things are going to have impact on legislation here in the future.
That's right.
And I'd like to know what you think of this, Tony, and you too, homeowners, about this new law that took place. Let me tell you what the story is. The backstory is that there were 4 college students who are caught in the middle of a condominium association battle. And this is in Fort Myers, Florida. 4 college students thought they'd found the perfect condominium to rent. It was close to their university in a great, quiet neighborhood. They thought they were having the best of all worlds. But then they, all of a sudden, started receiving a letter from the Homeowners Association. Now, the letter from the Homeowners Association lawyer said this, that they must begin paying the rent that they would pay to the landlord who owns the unit, now directly to the Homeowners Association. When the 4 asked the owner of the association what to do, the owner threatened and said, "If you don't pay me directly, I'm going to evict you." Now, these 4 college kids, they don't know what to do.
They're on the horns of a dilemma.
Yes. And so the person who wrote this story, and I think this was in the St. Petersburg Press, said, it turns out there is a new law on the books, started July 1st, that protects tenants from these kinds of fights. And we've got a copy of that here.
Yes,
And let me just read that. It says, if the unit is occupied, and this is state statute, looks like 718.116. It says, if any unit is occupied by a tenant and the unit owner is delinquent in paying any monetary obligation due to the association may make a written demand that the tenant pay the future monetary obligations related to the condominium unit to the association, and the tenant must make such payment. Goes on to say the tenant must pay the monetary obligations to the association until the association releases the tenant or the tenant discontinues tenancy in the unit. The association must mail written notice, and this is what I find interesting. You don't have to go to court or anything else. The association, all they have to do is mail a written notice to the unit owner of the association demanding that the tenant make payments to the association. After that, the association shall, upon request, provide the tenant with written receipts for payments made. A tenant who acts in good faith in response to a written demand from the association is immune from any claim from the unit owner. So they couldn't be evicted by the unit owner.
This first section of this legislation protects the tenant, tells them that, yes, it's okay for you to pay your rent to the association, and the unit owner cannot evict you for that reason.
Folks, are you on a board? What do you think? Do you think this would be a great idea to have in your association, to have the state be able to back you up and just getting rent money?
Well, it's come up in our office.
Yeah.
By the way, call us at 651-289-4488.
Let's do it just a little bit more slowly so people...
651
Yes.
289 4488.
Yes, because people always tell us we always do that real quickly. So
Okay.
Yeah.
This has come up in our office, and because I do rental management, other property managers in the office have come to me and said, our board is so frustrated. This owner owns 6 months of back dues, and he's got his unit rented out, and we know he's collecting rent every month. He's got income from that property, and he's still not paying us. So this is a real issue, and I can see that Florida wanted to help homeowner associations in collecting those delinquent assessments by doing this.
You stop and think about, like we said, the way the state of Florida is. I mean, they are known. I mean, they have so much high density in population in housing units, in terms of condominiums and high rises. That now you take a look at. I'm sure a lot of those are rentals. That was the thought that just crossed my mind. I wonder if how many HOAs in Florida have prohibitions on renting.
Well, our guest a few weeks back, Jan, and I'm sorry I can't remember his last name, he mentioned that. He said so many associations prohibit rentals, and this is a way, in Florida, this is a way that homeowners could avoid foreclosure if these associations would allow rentals.
When I think about about buying a home in Florida, I'm thinking of a neighbor of ours who they live here in Minnesota, just down the road from my wife and I, but they have a vacation home. So they bought a second home in Florida, a condo, and to them that's like buying the cabin. And so they go down there and spend time, but until they retire, which is maybe 15, 20 years down the road for them. In the meantime, they're renting it out so that hopefully a number of the payments can be made by a renter as opposed to themselves. Yes. A good idea, and that's why they bought like that.
Yep. I understand the sentiment or the reason behind this legislation, but I have also seen boards in our state draft addendums to leases that they require their landlords to use that say this kind of thing, that say, if Mr. Unit Owner, you default on your association dues and you have a renter, we can step in and start collecting the rent. So there's addendums that association boards are trying to enforce that say similar things. I've also seen in these addendums a clause that says, if the board is unhappy with that renter, if that renter is breaking rules and the board doesn't like how they're behaving, the board can evict them. And I always have a problem with those addendums.
I think we've said that if you're talking about a situation, Tony, where the governing documents had in their covenants from the very beginning, before someone purchased that kind of specific language, I have no problem with that whatsoever, because you don't have to buy that unit.
And when I bought my unit there, I was told, it was disclosed to me what the rules were about rentals.
And so I can make the decision to buy or not to buy. The issue that we have is when homeowners' rights, when you deal with something as major as this, after the fact, after the person purchased, because, as you know, a person may not be able to sell right away.
Yes.
They may not be in that position, and so to make a major change like that, I don't. I think we would agree that it would be poor footing for an association board to be on to start making
That's
those
right.
in the rules and regulations.
Because I don't believe a board can draft a rule that contradicts their governing documents or that is not supported by their governing documents. So that's one issue. We're seeing this kind of thing going on here, but there has not been state legislation supporting it yet.
But, there's other things that are already in place that I think you don't need to go to this level to get this accomplished.
You don't need to draft entirely new legislation?
No, I don't think so. But, let's wait until after this next break to talk about that. Again, what do you think of this idea in Florida? Is it a good idea for associations to be able to grab money from delinquent homeowners who are renting out their unit? Tell us what you think at 651-289-4488. We're taking a break now. We'll be back after these messages.